should say my name is Burgis. I'm a member of faculty at UNSW Law, and it's my pleasure to introduce you to Professor Ben Saul, who's a Professor of Law at the University of Sydney, author of many books, among them recently his edited volume on the research handle on international law and terrorism, but perhaps most famously defining terrorism in international law. And Michelle Burgis-Castalla, who comes to us from two places simultaneously, from the ANU, where she's an ARC Research Council, Australian Research Council Fellow, and from the Edinburgh Law School, from which she is on leave. And Michelle's work is represented by a number of pieces of writing, but in particular her book, Boundaries of Discourse in the International Court of Justice, Mapping Arguments in Arab Territorial Disputes. So each of the speakers is going to speak for about between 15 and 20 minutes, and then we'll have around 15 minutes for discussion. So I'd ask you to hold your questions to the end. Thank you. Okay.
Thanks, Flo, and good morning, everyone. This is working, great. I'm really delighted to be here, and particularly in such a civilised forum like UNSW. A few weeks ago, at my university, Sydney University, an Israel-Palestine event erupted into a riot, so it is said, and disciplinary proceedings are following. So it's great to see such a civilised discussion back at my old law school, where I started academics years ago. I've been asked to speak for about 15 to 20 minutes, but I noticed that UNSW clocks have been going backwards all day, so I can speak as long as I like, if I get to 15 minutes. And hopefully by the end of today we'll be back before 1967 and everything will be fixed. I'm talking today about whether there's a type of resistance in international law, and I'll say a little bit about how that plays out in Israel and Palestine without dwelling too much on the specific controversies. I think the first point, very simply, is that there is no right of rebellion or resistance by force or violence in orthodox or conventional public international law. It was discussed during the drafting of the Universal Declaration of Human Rights in 1948. There was a good Canadian socialist, John Humphrey, the Secretariat of the United Nations back in 1947-48, and he popped it in there in a first draft, but it hit the cutting room floor fairly promptly because, as you can imagine, most governments don't want to authorise violence to overthrow themselves. A few national constitutions do recognise the right of rebellion. A US study recently suggested about 37 national constitutions recognise the right of rebellion, but most of those don't recognise the right of forcible rebellion. In other words, passive or peaceful resistance may be licit, but using violence, even against unconstitutional governments, is not usually licensed, with some exceptions. That brings us to really where the guts of this debate is at, and that really centres around two legal frameworks. The international right of self-determination of peoples, number one, which I'll talk about firstly, and then the international law of armed conflict, specifically the law of occupation, which applies in Israel-Palestine. So far as the right of self-determination goes, of course, this was a big thing in the drafting of the United Nations Charter after 1945. You know, the way forward to settle conflict for all time, so it was thought. During the decolonisation process, during the 60s and 70s, there were huge debates between blocs of states, you know, the Soviets, the Western group, the developed states, about how self-determination ought to be achieved and what means can be pursued to secure it. Really, it's ended in a stalemate, is the short way of putting it. On the one hand, resolutions recognise the legitimacy of self-determination struggles and the right of other states to assist such struggles. But in order to achieve consensus, there was deliberate ambiguity in most of the resolutions to enable most states to vote for them, whereby, although there was agreement that we can struggle for it, there was no agreement that such struggle would be violent or forcible. And this obviously carried through to what other states could do in providing assistance. It had to be non-violent assistance. the same time, resolutions recognise a duty on states not to forcibly or violently suppress self-determination movements or to assist other states to do so. What this ultimately means is that there is no express right of people to seek self-determination by force. At the same time, international law doesn't authorise it, it also doesn't prohibit it. So if you think about the United Nations Charter, it bans the use of force between states, resort to force by states. It doesn't say anything about the use of force by groups. In other words, non-state actors like people trying to liberate themselves. What this means is that there are no international legal consequences for peoples who do use force at the level of collective or group responsibility. And there's considerable sympathy for liberation movements that use force in response to in response to states forcibly suppressing. Now, whether Israel is forcibly denying self-determination depends on your assessment of the facts. I think the relevant facts are, of course, that Israel has purported to annex as its own sovereign territory some of the territories. You have to think about the real purpose of Israel's occupation, whether it's directed towards, as the International Court of Justice says, establishing facts on the ground through the building of settlements, and thereby creating the final solution for itself. You need to think about whether whether the delays by Israel and Palestinians in a negotiated settlement following Oslo is a result of bad faith or good faith. And obviously there are arguments on all of this. Where that then leaves you really is that the nub of this is regulated instead by international humanitarian law. In other words, even if you do have a right to fight violently for self-determination, you've still got to respect both international humanitarian law and international human rights law. That's the way international law works, for better or for worse. Under international humanitarian law, of course, violence deliberately targeting civilians, including Hamas' indiscriminate rocket strikes, are of course war crimes. I mean, there's no serious debate to be had about that by any serious international lawyer. If you deliberately target civilian objects, it's just a war crime, and there's nothing much more you can say about that in terms of the black letter law on this point. The key thing, though, is that there's a really important series of other rules in humanitarian law, which is really where all the controversy and action is at. And that is whether, if you fight against military targets, in other words, you attack the military objectives of the occupying power, how is that regulated? How is that characterised as legal or illegal under international humanitarian law, as the case may be? Now, here it gets a little bit tricky, because humanitarian law classifies conflicts into international and non-international armed conflicts. On the one hand, it's clear that part of the Israel-Palestine dispute is an international armed conflict, because, as the International Court of Justice said in the Israel War Advisory opinion, this was territory, foreign territory. Yes, there's a dispute about sovereignty, but who cares? Foreign territory taken in an interstate war between Israel and Jordan in 1967 and held ever since by Israel. Therefore, the answer under humanitarian law is pretty straightforward. That's an occupation. That doesn't mean, though, that all fighting between Palestinian armed groups and Israel is automatically governed exclusively by the rules of international armed conflict and the law of occupation. This is where humanitarian lawyers and international lawyers divide. Some suggest that the applicable rules ought to be the rules of international conflict, the law of occupation, and they should apply to the Palestinian fighters. Others, and I think this is probably the more orthodox or mainstream international law position, would say that yes, there's an international conflict by virtue of occupation, but there's a simultaneous, parallel, non-international armed conflict between a state, Israel, and a non-state armed group or groups, Palestinian Jihad, Hamas, and so on. But let's set aside for the moment the debate about whether Palestine is yet a state. The most conventional debate along these lines goes, Palestine isn't yet a state, therefore forces can only be part of the international armed conflict conflict if they, in the words of the Geneva Conventions, are forces belonging to a state. And obviously Palestinian forces don't belong to Jordan. Jordan's no longer in the picture, and if Palestine's a state, these are just non-state armed actors fighting in a non-international conflict, and therefore the rules of non-international conflict apply to them. Now this all seems a bit weird because we accept that self-determination is the right of a people to really choose to be a state if they so wish. So self-determination movements are really not like civil wars, and it's not like Tasmania taking up arms against the Commonwealth government. It's more like Australia and New Zealand going into battle against one another. Self-determination movements are really de facto states in waiting in a way. International law does take account of this. So in 1977, an additional protocol to the Geneva Conventions was adopted. It internationalises self-determination struggles which were previously regarded as non-international under the Geneva Conventions of 1949. The problem is Israel hasn't signed it, and therefore the old law still applies. It's still a non-international conflict, artificially treated as just like any other civil war between people and their own government. The only other occupation situation really where this self-determination protocol matters, the relevant state also hasn't signed it. Morocco occupying Western Sahara since 1975. What this means, and this is the critical part, what this means is that under the law of non-international armed conflict, states are free to treat as domestic criminals under national law anyone who opposes the authority of the state, including the occupying forces. In international conflicts, by contrast, combatants, legitimate state military forces get what we call combatant immunity for lawful acts of hostility. So if an Australian soldier targets a New Zealand soldier in an international armed conflict, the Australian soldier, and comply with the law of war, the Australian soldier cannot be tried for murder, assault, terrorism, or any other domestic criminal law offence that a foreign state wishes to throw at that person. You get an immunity, because the point of humanitarian law is to enable, on one hand, the protection of civilians, on the other, states to target and kill each other. I mean, there's not a lot that's particularly humanitarian about that, but this is the balance to enable wars to be fought. Where this leaves you then, and I think this still is the case, regardless of whether you treat the conflict in Gaza and the West Bank as international or non-international, really the same consequence applies here. If it's a non-international armed conflict, Palestinian fighters can lawfully, under international law, be prosecuted for whatever domestic offence they've committed, according to the Israelis. That can include terrorism offences. If, on the other hand, you say it's an international armed conflict, the Palestinian fighters probably do not meet the conditions of combatancy for irregular state forces, irregular forces belonging to a state under international conflicts, and therefore wouldn't get combatant immunity anyway. What that means is that they're just civilians or groups of civilians, what we call, in technical terms, taking a direct part in hostilities, and for such time as they participate in hostilities, they can be targeted, and every other time they can be arrested and prosecuted and put on trial in the same way as if it were a non-international armed conflict. So this is a long way of saying international law doesn't give self-determination fighters not covered by Protocol 1 of 1977 very much by way of a right of resistance. The best humanitarian law does is to say, at the end of the conflict, you should let them go. To recognise that it was really a serious disruption of political order. It's not like a regular murder or a criminal, and make reparation and rehabilitation of society through that means. Okay, so that's the orthodox position. Now I want to say something about what's happened since 9/11 in all of these, what was it, global counter-terrorism laws. In the 1970s, during the General Assembly debates, there were huge controversies over whether an international convention to prosecute and punish terrorism, which had arisen partly because of Palestinian militants, terrorists, fighters, call them what you like, going around attacking airports, blowing up civilian airliners in order to bring attention to their cause. The General Assembly got in on this. There was paralysis because of the Cold War and development politics and so forth. And there was this long-winded debate throughout the whole of the 70s pretty much, whereby a bunch of states on one side, developing, decolonising states, said you can't call liberation violence terrorism. This is I'll give you the short version. On the other side, the Western states and their mates said terrorism is always terrorism regardless of colour. And you had a whole spectrum of debate in between. Some saying liberation violence shouldn't be called terrorism and shouldn't be dealt with as anything else either, even war crimes. Some in the middle saying just don't call it terrorism because it's stigmatised and nasty, and terrorism is really the US bombing of Vietnam and Cambodia and Laos, blah, blah, blah. But instead, just let it be prosecuted as war crimes. And other stuff, just don't call it terrorism. And then you had other states saying, no, it may be war crimes, but we should still call it terrorism. Because if you're deliberately going around blowing up civilians, that's nasty and we should call it for what it is. A bunch of the states then said, yeah, but you can't deal with terrorism until you address the root causes. i.e. the Soviets would say, the exploitation of workers in a global capitalist economy. The decolonising states would say, colonialism and the suppression of self-determination. The Western states said to that, well, we know there are causes for murder, but you still prosecute it pending the resolution of the causes of murder for all time. The result was a deadlock and really nothing happened. This takes us to 9/11. The critical change, and this is really a revolutionary change in international law terms, because for about 90 years, the world had been, ever since the time of the League of Nations, the world had been trying to define terrorism as an international crime ever since some Balkan separatists in the 1930s blew up the king of Yugoslavia. No success. And then suddenly 9/11 comes along. A couple of days, very soon after 9/11, the Security Council says to all countries around the world, you must criminalise terrorist acts in domestic law and through passing legislation to that effect. But we won't define terrorism for you. You can do that yourself. So 200 states go off and over the coming decade get busy unilaterally defining terrorism as they like, often to punish their own domestic political enemies, suppress freedom of human freedoms, etc. Why this was particularly pernicious from the standpoint of liberation forces and other domestic insurgencies is because I said earlier that it's always been okay for governments in non-international armed conflicts to criminalise their domestic opponents, rebels, insurgents, liberation forces, and so on. But normally what happened was that other states didn't get in on the business of doing that for them. So to make it real, let's say someone tries to assassinate Hitler, Tom Cruise in that awful movie tries to assassinate Hitler, flees to Australia. Under the conventional position, Australia wouldn't extradite Hitler's assassin back to Nazi Germany. After 9/11, what a bunch of states did was criminalise terrorism and extend what we call universal jurisdiction over it, which means essentially this. Under Australian law, and it's the same under British law, a bunch of other countries are quite similar, it's an offence for any person, anywhere in the world, to use political violence against any foreign government. So if you're trying to overthrow Hitler, that's terrorism under Australian law. If you're trying to overthrow Assad, that's terrorism under Australian law. You're trying to dislodge the Israeli occupation, that's terrorism under international law. Any political violence is covered, including under the Australian and British definitions, violence regulated by international humanitarian law. So what this now means is that even if a fighter only targets military objectives of a foreign state, does it in a way which accords with international humanitarian law, you don't pretend to be a civilian, you don't use illegal weapons, you don't indiscriminately kill civilians along the way, that's still terrorism under Australian and British law. In other words, there's no what we call carve-out or exception for international humanitarian law and other law. Whereas pre-9/11, what generally happened in most foreign laws was that it was left to humanitarian law to regulate. if you killed civilians, it's a war crime, and that was always prosecutable under Australian law since the 1950s. But it was never an offence to go after a nasty foreign government, an authoritarian, repressive, autocratic government, and so on. So now we're in a situation where laws of democracies punish resistance with very serious criminal penalties, life imprisonment in many cases, for people who try to overthrow the nastiest, most brutal regimes on the planet. And I think you can imagine from the tenor of my remarks that I don't think that's a good thing. Where this leaves us, to conclude, is this. International law does some good things in all of this, and it does some pretty rank things in all of this. Along the way, liberation movements and other insurgent groups have often made a whole series of arguments to try to challenge international law. How international law has been made by states who are the ones who make it. I just want to leave you with really a categorisation of what are the most common challenges to the logic of international law on violence in this era. Point one, a lot of liberation forces have always said, well, humanitarian law gives states too much and gives us too little. States, on the other hand, say, no, humanitarian law, particularly Protocol 1, gives liberation forces too much, it's a license for terrorism, and gives us too little. But the point is really this. Humanitarian law expects that before you attack a state, attack state forces, you have to carry your weapons openly prior to the attack. In the Israel-Palestine situation, it goes like this. I was in Israel last week at an expert meeting for the Israeli Defense Forces. I heard a lot of comments like this. Hamas terrorists are violating humanitarian law because they are not fighting in the open areas of Gaza, but are intermingling themselves among civilian buildings and civilian populations. So the Israeli assumption is that before you start fighting Israel, you should come out into the open. In other words, you should carry your rocket out into an open field where, and it's true that there are lots of open fields in Gaza. Everyone thinks Gaza is just buildings. It's not. A lot of Gaza is actually empty fields. But Hamas' view would be, well, if you do that, given and I went to the southern Gaza command base of the Israeli Defense Forces, they have amazing technology. I mean, they can, if a rabbit pops its head out from under the field, it will be dead in a minute. I mean, the technology is incredible. So the Hamas argument is, if you expect us to do that, that's suicide. I mean, we can never fight like that. And actually, urban guerrilla warfare in civilian areas has always been an accepted part of international humanitarian law, as long as you don't, as Hamas had done, place rockets inside or next to schools, for example, which is clearly unlawful. Another version of this, a couple of years ago, France gave the Legion of Honour, the highest award of the French state, to a very elderly French grandmother who, during the Nazi occupation of Paris, was cycling her bike one day along the Seine River, saw a Nazi officer admiring the view, there were no surrounding hostilities. She cycles up to him, gives him a big smile, he thinks he's going to get lucky. She pulls out a pistol and shoots him dead in the head on the spot, and she gets a Medal of Honour for doing that. That's illegal under current humanitarian law. It's what we call the war crime of perfidy, because it's concealing yourself as a civilian in order to mount an attack. So in Europe, that's resistance, forces doing the right thing under the current law. This is precisely why terrorists think the law doesn't give them enough. Other arguments, I'll just rattle these off briefly, so I need to wind up. An argument often put that certain civilians aren't really civilians, so settlers are a classic example in French Algeria in the 1950s. Frantz Fanon, the armchair assassin of French philosophy, said this: the appearance, this was talking about Algeria, the appearance of the settler has meant the death of Aboriginal society, cultural lethargy, and the petrification of individuals. For the native, life can only spring up again out of the rotting corpse of the settler. In other words, the argument goes, settlers aren't like other civilians, they're more like soldiers because they're sustaining the occupation, etc. The humanitarian law point of view on that, of course, is that you can only target people who are militarily dangerous, not people who are morally suspect or politically disagree with, and so on, because that's subjective, not objective. Final couple of arguments. Very, very simple one, and this used to be part of humanitarian law and is no longer. It's what we call a doctrine of reprisal. Israel kills a lot of our civilians, so we'll just kill a lot of theirs, tit for tat, in retaliation. That's illegal under humanitarian law. An argument of necessity. This Ted Hondrick, a British philosopher some years ago, said, well, yes, we recognise humanitarian law, but in circumstances of grave emergency for society, you can justify, going outside law. Necessity is the mother of law, in the way that Bismarck put it many years ago. So Hondrick says Palestinian suicide bombing for humanity is okay. The West said in the Second World War, firebombing enemy cities, dropping atomic bombs, that's okay. It's kind of short of the war, it makes us weak, and you can't have to do that. So it's this illegal but justifiable idea. Isaiah Berlin, of course, famously said of that this is the absurd revolutionary idea that you have to break eggs to make an omelette. You never actually end up making the omelette, you just end up becoming as evil as the people you're trying to stop. Finally, I'd just say, the most extreme challenge put by some of these insurgent groups is not to ground, all of the prior arguments I've been mentioning are ones which challenge humanitarian law on its own terms. A more extreme argument, of course, is put by those who just don't accept humanitarian law or international law, Islamists who believe in Sharia law, don't care for secular international law made by secular governments. They follow their religious nose on their own beliefs. So I think, as you can see, this is a pretty vexed space. International law has reached certain normative agreements. There are all kinds of challenges to those agreements. But I think, if you believe in human dignity, if you believe in human rights, for all the flaws of modern international human rights, I think at a minimum you have to oppose the instrumental destruction of civilians for political ends, which is really the guts of what I think terrorism is when I try to define it. If you go on to say attacking governments through military means is also terrorism, I think you step across a boundary which shouldn't be stepped across. I think that makes any resistance to Nazi or to nasty authoritarian, totalitarian governments impossible, and you end up destroying the human rights in the process. Thanks.
Well, thank you very much to the organisers and to everyone here in the room. I'm just going to offer a series of thoughts that are rather unformed at the moment, but they very much stem from my own experience working at Al-Haq while Hal was there, and then also doing some follow-up research myself where I interviewed a number of Palestinians working in the human rights field and in the international law field in general. And through my own reactions to the occupation, as well as hearing from Palestinians themselves, who largely were working with law, I constantly came across this binary for Palestinians in terms of resistance, that either their choice was violence, and we've heard some of the possibilities that are available through the violent course, and the Palestinians have tested that over decades. So we have the violent path that can be chosen, or we can have the legal option. And I think that today we can list a whole series of legal options that Palestinians have pursued, whether it be going to the International Court of Justice, whether it be trying to achieve statehood within the UN or beyond it, becoming a member of the International Criminal Court, invoking human rights within military courts, within the Israeli High Court. So I mean, there are a number of ways that as well Palestinians can turn to law. What I struggled with, though, in trying to think about how to respond to the questions put by the organisers for this talk, is actually how to break down that binary, okay, and how, in fact, war and violence throughout the conflict, from any perspective that we take, are intimately connected. Particularly, we may think that human rights is very far removed from violence. violence. Human rights typically are concerned with the regulation of societies in peacetime. You know, if there's conflict, we maybe rely on IHL, but for peacetime, we can go to human rights. So typically we may associate human rights largely with a way of forestalling violence, as a way of maintaining a peaceful society. But in fact, I think as well, we need to explore the extent to which human rights are a product of violence and the way that human rights themselves can also sustain types of violence. And so I think I'll try to end this talk by trying to show the link here within the occupied Palestinian territories between human rights and structural violence. Because although, of course, we can list a number of actual violence problems in both Israel and Palestine towards both Jewish Israelis, Palestinian citizens of Israel, citizens in occupied territories, such as murder, rape, assault. I think for our purposes, if we're trying to think about how to use the law creatively to resist, then in fact we need to perhaps think more about the phenomenon of structural violence. So hopefully I'll get to a point where we think about human rights through structural violence. So I'm going to do that by giving you a little bit of a history of the conflict, choosing some key moments, basically to illustrate that at every turn in this conflict, law and violence are intimately related. And in fact, the legal doctrines that we rely on today are all a product of violence, both in its structural and its actual terms. And I would say we've got to the point today where, yes, international humanitarian law is in some ways still the default register for some of the questions that arise, but in day-to-day life, it is largely human rights law, particularly as a mode of discourse for resistance at the international level, that is the dominant discourse that Palestinians resort to, okay? And so we need to understand how we got to that point of reliance on human rights. What are the possibilities of resistance through human rights, and what are the shortcomings? Because of course there are many. We need to think about the extent to which human rights that have become hegemonic offer possibilities of counter-hegemony, maybe through this idea of structural violence. And then I would link here international criminal law as well to that project as a sort of more recent outgrowth of this human rights industry that we've seen emerge in Palestine, particularly since the 1990s. So in terms of, before I go my moments, in terms of thinking about resistance and law, Sally Mary gives us a nice way of thinking about the relationship between resistance and law. One way is to think about resistance to law. Yeah, so you're oppressed, you try to resist the law. And we've heard some examples from Amira with that. So just classic notions of rebellion or disregard for law. Not acknowledging the law for its legitimacy. We can then also think about resisting with the law, using the law to help resist the case. So, and I think often this is then accepting the broader legitimate nature of the legal framework. So here, again, Amira's examples whereby you can try to get your little bit of freedom, for example, to release your child from detention, by engaging with the law, by trying to claim your rights within the system, and so therefore you're using resistance and law together. The problem here is that often in doing that, resisting through law, perhaps you're actually reinforcing the border structure. And this is the problem, and this is where we get back to structural violence, I think. Structural violence, in this case, not only of occupation, but perhaps the nature of Palestinian society generally in what I would call the Oslo regime. I don't think the only problem for Palestinians is the occupation. And we might talk about that at the end. And then the third type of resistance that Sally Mary talks about is resistance that changes law. Okay? And I think this is the most interesting for us because it's so easy to depict various types of law as but also counter-hegemonic, to try to find those spaces. And so I suppose the story that I'll very, very briefly plot out in my moments through the history of the conflict is to try to pinpoint where we have different types of resistance and ultimately to try to work out where there may be openings for the third mode of resistance, which is resistance that actually changes the law. And I think we'll see that throughout this history, there's always going to be a combination of possibilities for resistance. And in fact, given how legalised the conflict has now become, perhaps there are more openings than ever before. I mean, you can read it as both a story of absolute despair, yeah, that law is just so effective in shutting down dissent, or let's try to think about other ways of trying to find spaces as well for opening up possibilities here. And so the moments I'm going to skirt through extremely quickly, how we can link resistance and law in the pre-mandate period, then the mandate period, then the period that establishes the State of Israel and the occupation of 1967, and then I'm going to shift to the First Intifada and link that with the rise of the human rights field. And then if I've got time, talk about what happened post-First Intifada, i.e. the Second Intifada, and the Gaza disengagement, and the shift to various other registers of international law that we see. And so I think during the First World War, which saw ultimately the breakdown of the Ottoman Empire, no Israeli state, no Palestinian state at that time, no real sense of a clearly defined Palestinian national identity, obviously quite a strong Zionist movement at this point. The role of international law at this point, I think we can very simply put in classic colonial terms, whereby we had a number of private backroom deals that took place between Western powers, and here we have a type of colonial violence, coupled with a really creative, frenetic violence that was the Arab Revolt. There was an attempt at the end of the First World War, largely inspired by Britain, to bring about some type of self-determination. So even at the very beginning here, we have this link between violence and self-determination and the possibility of a new type of society that could be brought about. Now, that didn't happen. So we have still here a very sort of simple story, ultimately, of law as domination, of control, because law at this point was largely a European international type of law that would bring about the mandate system. But I think here we already have this really nice tension between resistance and law. I think I can't describe how central the mandate period was for everything that came afterwards. Okay, so we've already touched on it a little bit today, but I think really, if you look at some of the mandate documents in detail, they set up already a very clear vision for separate development of two communities. If you actually look at the terminology used, there is a differentiation already between the Jewish and Palestinian population. So by 1922, this distinction is crystallized not only as two different peoples, but two different peoples with different mandates. Sorry, excuse the use of the term there, whereby Jewish mandate, the Jewish development would be conceived of in more modern, civilized, Western terms. These are the classic notions of liberal democracy, whereas Palestinian development would be along cultural, social, religious lines without any clear sense of a political community. And if you think about the way human rights is ultimately dependent upon, I think, a mature sense of a political self, okay, of a rich political community, already at this moment we have an emasculated space for Palestinian human rights to realize themselves. Unless you actually have a richly conceived society through which to realize human rights, they're always going to be forestalled. And I think that the mandate in many ways actually set this up. So we have international law then in many ways sanctioning this differentiation between societies, the Palestinian and the Jewish society, throughout the mandate period. And many Palestinians had serious problems with this, and so as well, perhaps the high mark then for law, or the lack of, depending on how you define it, at this point was again another revolt between 1936 and 1939, which was an extremely well coordinated, in the sense of mass revolt that went on for 3 years against the British presence there. And this again, then we can read very much as resistance to law. just classic foreign domination whereby no longer could you really call the mandate anything else but old-style colonialism. And I think, though, that what was vital for this period for Palestinians was that the way that, like it or not, violence was, and also the imposition of foreign law were crucial in solidifying national identity. So what I'm trying to show here is that there's a really important relationship between how you define yourself and how you crystallize that, sometimes through violence, okay, and how you define yourself in opposition to foreign law. And that was definitely the case during the Arab Revolt. We then have, partly as a result of the troubles that the British encountered during the Arab Revolt, increasing unease by the British in terms of how to deal with the problem of their mandate. And so after the Second World War, we had, I would say, a much greater turn to the international legal level for the regulation of the Palestine problem. I mean, as we know, we get the creation of the State of Israel in 1948. But before that, I think we see for the first time, perhaps, Palestinian and Arab attempts to use war as resistance at the international level with lobbying for different types of ways of partitioning Palestine. The possibility to think about the historic Palestine in more just terms, okay, that didn't necessarily follow the Balfour Declaration that was incorporated into the British mandate. Now, as we know, this was unsuccessful. Not only was the partition plan, which Palestinians and Arabs would say was patently unfair, not followed, it was truncated, and we had the creation of the State of Israel. But at least here, I think there's some resort to the international legal field as resistance. Once we have the State of Israel, I think we have increasingly law imposing the terms of debate and resistance, particularly if you think about boundaries. So before 1948, before the debates on partition in 1947, very much people thought of historic Palestine as one unit. And yet in the room, people very much take for granted, obviously the boundaries of of Israel in 1948, but often the debate tends to start from 1967, i.e. After the Six-Day War, when Israel occupied the West Bank, East Jerusalem, the Gaza Strip, as well as the Golan Heights, Syrian territory. But I think we need to step back and think about the extent to which international law from 1948 has actually structured the way we think about this conflict. So for some Palestinians, there is still a lot of resistance to actually starting from 1967. When I interviewed them, they kept wanting to go back to 1947. They kept actually trying to say that in some ways the greatest injustice was these debates around partition, and actually trying to invoke a sense of international law that could acknowledge other types of ways of configuring the territory. But I think that at this point today, very much we have to take the 22% of historic Palestine as potentially the only part that is up for debate in all of this. So once Israel was established, law was extremely insignificant, I would say, both domestically and internationally for both Arab and Palestinian forms of resistance. The main mode of resistance from the late 40s, 50s, 60s wasn't really the Palestinian resistance per se, it was Arab nationalism. It was very much about negating the state in some ways, about valorizing types of violence, about trying to eradicate Israel's presence on the map, as a political entity, not in terms of getting rid of Jews, but as definitely challenging the type of regime that had taken place in parts of historic Palestine. So at this point then, resistance very much was a transnational phenomenon. Violence was fundamental to this, often state-based though, because we had Arab regimes as the exemplars of resistance, and we had a number of conflicts during this period, 1956, 67, and 73. But increasingly, Palestinians within the occupied territories, and then Lebanon in particular, realized that they would actually have to rely on themselves. I mean, this is a narrative about the fair bit of Arab nationalism here. And the question then for Palestinians is, how do they resist? Okay, if they can't rely on various Arab regimes that ultimately failed them, how are they going to somehow stop this long trajectory of domination by Israel. And initially, the classic imagery here would be of the formation of the PLO, of the violent militant fighter. And I don't think really it was until the failure, let's say, of Palestinian resistance in Lebanon, when the PLO was forced to move from Lebanon all the way to Tunis, so that there was a massive dislocation between violent groups and local Palestinians in the occupied territories, that there had to be some question within the occupied territories themselves about, okay, what are we doing? For decades there have been these reliance upon violence, not very much recognition about how to use law creatively within the occupied territories themselves. No real mass civil disobedience as well. We heard from American initiatives like, well, okay, we'll just see what happens. But really no strategic thinking at this point, okay? Now as well, remember the 1970s is the moment where human rights becomes significant. Although we have human rights documents from 1948 with the Universal Declaration of Human Rights and then the series of the covenants and specialized treaties, it wasn't really until the 1970s in Latin America that people actually started taking up human rights on the ground. And so, in some ways, post-1982, with the exit of the PLO in Lebanon, we then have, and obviously a massive frustration amidst the Palestinians in the OPT, we have the moment where perhaps law as human rights can be tested, and that moment really is the Intifada. And so again, I'm trying to show you here how the Intifada that erupts in the late 1980s is, again, this confluence of law and violence. And I think the first Intifada is a wonderful expression of people trying to realize their self-determination through largely non-violent resistance. Okay, law as well at this moment is not necessarily central, but very much the first Intifada did become a training ground for later human rights, civil society organising. And if you think about when the first Intifada erupted at the very end of the Cold War, and then of course what happened after the end of the Cold War in the region in terms of the Madrid Conference, and then the Oslo Accords that took place in Palestine, then we had this wonderful relationship then between mass civil disobedience of the Intifada and the rise of human rights. The problem though with this story is the way in which human rights increasingly, I would say, in Palestine and elsewhere, have become decollectivized, individualized, and internationalized. Meaning that what I was trying to say about how human rights, for their most potent force, should be grounded in a mature political community, that's exactly what's not happening in Palestine. Because the constituency of human rights in Palestine is largely the international community or donor funding interests. And so often we will see instrumental uses of human rights in various ways that can be invoked, i.e. resistance through law, resistance as law, that may appeal to the international dimension without necessarily bringing in the interests of the Palestinians on the ground, and particularly in very individualized, ad hoc, fragmented ways that I think breaks away from, as I was talking about, this far more collectivized notion of self-determination that in its violent and non-violent capacity, I think was captured most brilliantly during the Intifada. So I mean, I think especially since the first Intifada, we've had then a real breakdown in the possibility of thinking about a human rights that is truly collective, okay? That can somehow incorporate self-determination, because it's the irony that the first article for both the covenants of the International Bill of Rights has self-determination as the first right. So not only can we think about self-determination perhaps in terms of international humanitarian law, but it is also in some way the pillar of the human rights system, and yet it's non-justiciable. We can't actually pursue it as a claim for an individual because of its collective nature. And so in many ways, Palestinians then have had to resort instead to individual instances of human rights violations without actually getting to the core of the problem, which is how the self should realize itself, in a political space, which, as I said, I'm running out of time, is not simply about ending many of the problems that Palestinians encounter today are also ones of Palestinian society itself. In terms of, say, domestic violence, for example, or just a lack of vision as to how society should be run, problems of neoliberal development, and how that's fragmented society further. So in many ways, I think this sort of possibility of using self-determination creatively through human rights would be a chance for Palestinians to end their focus on individual actions and activities, and instead to perhaps try to reconceive of what their political community may look like, not only as liberation from occupation, but liberation from all types of oppression, and that needs to then be an internal focus as well. And so really then the question needs to be how self-determination can allow Palestinians to confront problems of structural violence, which is basically the problem of taking for granted or accepting everyday forms of oppression, not just at the point of a gun, but as to how you see yourself as a human. Thank you.
Thank you so much, Michelle. So we are now in the lunch break. So if the organiser, I thought I'd just take one round of 3 questions and then we can have discussion over lunch. So,
my name is Michael Wood. So I just had a couple of questions for Benzo. I read these books, by the way. So one is, I was quite interested in what you said in relation to the rules of international law in relation to the conflict between the Palestinian militant groups and Israel. And one thing that you said, which I'd like you to possibly expand on, was you said belligerent. I think reprisals or belligerent reprisals are banned under international law. And there's, you said something like there are no international lawyers who dispute that. And I think I read an article by John Dugard, the South African jurist, who made a case, which I hadn't seen before, that there was some grey area in publicity. How does that? So if you discuss that a bit, I appreciate it. And the other thing I'd like to possibly comment on is I know it seems like it's Jewish news, that one of the op-eds discussed you at some a little bit. So the guy from Rogers said you, I think, called you the infamous article last year, possibly the year before, where he claims you wrote about the dual loyalties of Jews in Australia. Seems to suggest you're anti-Semitic. So if you could just comment on that, I'd appreciate it. Thank you.
2 more questions.
Peter Miller, addressed to Ben, you said that the mass shooting was a war crime. But in Israel, aren't all or most Jews in the military from the age of 18 to either 50 or 60? And if so, if that's the case, why is any part of Israel not military?
Paul Rubner, question addressed to either or both of the speakers. Isn't there a dilemma between presenting the struggle for Palestinian independence in terms of a legal human rights perspective or a political resistance movement which might include non-legal means, including violence? Isn't there a dilemma, given that, as Amira House said, that in Israel law is buttressed to hegemonic power of the Israeli state, isn't there a problem, if you present it in political terms, in the wider context, then you leave yourself open to being accused of endorsing violence. And if you confine your framing of the struggle in terms of purely legal terms, then you're relegating yourself to a position of impotence.
Yeah, very briefly. First one, Michael, on reprisals. The Geneva Conventions of 1949 ban reprisals against civilians, which is what I was talking about. It is still permitted to undertake reprisals against military forces. So, for example, someone uses chemical weapons against us, they're not stopping, we use them against them to make them stop. It's a kind of extreme example. But that's against soldiers, not against civilians. On the Jewish news, look, I've always wanted to sue for defamation to supplement my meagre academic salary. So I'll look at that one with interest. I think short answer, am I anti-Semitic? Well, no, is the short answer. That article was about the allegations that dual Australian-Israeli nationals were involved in potentially activities potentially damaging Australian national security. In other words, forging passports and conducting operations disguised as Australians and so on. So the argument I made in that article was that Australia and Australian law ought to be concerned about Australian nationals, dual nationals of any persuasion. And the article mentions Chinese, Americans, precisely to demonstrate that it wasn't targeting Jews. Then we should be concerned about that. I don't think Australia should be spying on Australia for other countries. And I think Israel would probably expect the same of dual Australian Israeli nationals. I don't think that's unreasonable or anti-Semitic. Thirdly, question about all Israelis being in the army, are they fair game? Short answer, no, because you can only target a combatant as a combatant when they're on active service. So if you're a conscript or a reservist who's in regular civilian life and you're on call in the army, then you're a civilian.
But it's not the same with Palestine.
With Palestinians, the same rule applies. It's a different rule, but similar in substance. The rule is any person who takes a direct part in military hostilities while being nominally classified as a civilian or a combatant can be targeted for such time as they take part in hostilities. So if you're a Palestinian civilian not fighting at that moment with a gun in your hand, you're immune from attack. If you pick up a gun, you become a target. States would say, actually, the advantage here is with terrorists, because you can pick up the gun, and only when you're carrying a weapon can you be attacked. As soon as you put it down, you go back to being, a shopkeeper or a farmer. By day, militant by night, you can only be attacked for the few minutes or hours a day when you're not in military operation, but then you resume being a civilian. So it's this revolving door phenomenon. Why the targeted killings case, which I think Michael mentioned earlier in the day, was important was because it expansively interpreted the definition of taking a direct part in hostilities to say that you're taking a direct part in hostilities not only if you're just carrying a gun, but doing all kinds of other ancillary support activities for a militant group, and that was controversial, but also it expanded the duration or temporal element by saying, as long as you're committed to a chain of hostile acts, if you're carrying a gun and then you return to your shop, but you're still going to go back to carrying a gun the next day, you're still a militant for that whole period, not just the period that you've got a gun in your hand. And so that was controversial, of course, because that renders it more subjective in a way, but it does make, strangely, Palestinians fighters more like soldiers, because, of course, the classic position for soldiers is that if you're a uniformed armed member of the Australian military in war, you can be attacked at any time, when you're sleeping, in the shower, in the bath, on the toilet, undressed, not just when you're on an active military operation carrying a gun.
Thanks. So the question is, should we resort to violence or should we resort to law? What was your... Because you said that if the law, you would be impotent, yeah?
Well, it's, some people, advocates like Jeff Halper from the Israeli Committee Against Housing Conditions, has said that, you should frame the whole issue in terms of human rights. But he also talks about a matrix of control. Now, I think that matrix of control sort of idea ties in with the nation of law as an instrument of hegemonic power. So then there's a dilemma of how should what's the best way of framing, you know, the struggle basically, and how to pursue it? Or are both approaches, are they compatible in some way, say carried on by different organisations or people?
Yeah, so I think absolutely there's a spectrum, whether you want to, some Palestinians would say collaborate with the occupation, for example, to take part in the military court system, to go to the High Court, to in sort of everyday acts, legitimise the occupation. That's one choice you have, and there are ad hoc moments. But I think the bigger question is, can you somehow question the underlying illegality of the occupation itself? And I think that's what I was trying to get at. There's a wonderful, very long article by 3 authors, including Ornab and Nathalie, who talks about not only specific acts of illegality with the occupation regime. You can go to Geneva Conventions and list the various violations that have been carried out by Israel, but actually the broader question is the very nature of this type of occupation itself illegal per se, especially if you link it with other types of use covenants in international law, particularly the prohibition on conquest, which is of course what is happening in the occupied territories as we speak. It's just such quiet conquest. So I think, yes, I do think we need to understand what is going on as a very deep matrix of control, and just touching at the surface through sporadic activity of sort of low-level resistance, using law as resistance, will never dislodge it. I think we need to have a more systematic reappraisal of the system as a whole, and I myself would actually describe the whole system as itself, if not illegal, at least illegitimate. And there are some tools within international law I try to talk about, such as self-determination. Perhaps it can challenge that, but as Ben has also beautifully illustrated, there are other aspects within international law that wonderfully reinforce it. So there's no simple answer there, sorry.
Thank you so much I'd ask you to join me in thanking our panellists for a terrific presentation.